I'm Melina Morrison. I'm the CEO of the Business Council of Cooperatives and Mutuals. I'm delighted to be here with my colleagues at the Council today, but most importantly, our presenter from BAL Lawyers, an associate member of the BCCM. So Katie Innes is with us today, and we really look forward to Katie's presentation. Importantly to today's presentation, on the Cooperative National Law regime, we've been advocating for the rollout of the CNL regime since we commenced in 2013, and we're delighted and so pleased and very thankful to see the completion of the national harmonisation coming to fruition for the benefit of Queensland cooperatives. So with the enactment of the regime in Queensland this year, that full national harmonisation scheme has been completed, and that's what we're looking at today. So without further ado, over to you, Katie.
Thanks, Melina. Everyone, please excuse me if my technological skills are not quite there. This is the first Zoom webinar I've held. I've attended many. So let me just try and share my screen. So thank you, Melina, and thank you to the Business Council of Cooperatives and Mutuals for putting this on. I think it's really valuable to actually reach out and engage with co-ops that are going to be affected by these changes to the legislation. As Melina said, little disclaimer, it's not to be taken as specific legal advice relevant to each single co-op. I don't know what your true circumstances are, but it is intended to be a general overview of the legislative changes that are hopefully about to take place. So, as many of you probably know, co-ops were established many, many years ago as a form of ownership, probably over 500 years ago. In Queensland specifically, I understand there's about 19,000 members of co-ops with a collective gross revenue of about $250 million per annum. They're an important part of the economy and society, and they play to a number of different industries: agriculture, dairy, water supply, groceries, hardwares, housing, arts. It touches on all of our lives in some way. So it's extremely exciting to hear, at least from a lawyer's perspective, that there is now going to be this national harmonised legislation that applies to co-ops, giving co-ops, frankly, an even playing field. Firstly, amongst themselves, because, to date, previously, co-ops have been subject to different legislative regimes, and so they can't really compete amongst themselves. With the harmonised, they can compete evenly amongst themselves and evenly with other business structures that are subject to Commonwealth or legislation in that way. So currently, did it work? There we go. So Queensland co-ops are currently regulated by the Cooperatives Act 1997. Earlier this year, I think it was June 16, the Queensland State Government passed the Cooperative National Law Bill, and that's going to replace the legislation entirely, and that's expected to come into force next year in 2021. So more or less across the whole country, cooperatives are going to be operate under this one harmonised legislation, which is fantastic. And the idea behind the CNL is to enable co-ops to trade freely across state borders, not requiring separate registrations, not being considered, oh, I'm just bundled in my own little home jurisdiction, I need special permission if I want to trade across the border. It really is an attempt to relieve the administrative burden of multiple registrations, of multiple sets of reporting, and to encourage the development and the strengthening of co-ops at a local, regional, national, and even an international level. The CNL, just like the Cooperatives Act, is there to protect the interests of co-ops, protect the interests of the members, and to ensure that directors of the co-op are accountable for their actions and decisions, and accountable for their decisions, both to the public and to the members of the co-op. So today, what are we going to cover? There's sort of 5 key changes that I think are important for co-ops to know just going forward. First, there's terminology changes. They're fairly easy to understand. There's now this removal of regulatory barriers, so no more foreign co-ops requiring multiple registrations. There's also the introduction of large and small co-ops through the simplification of financial reporting and auditing requirements. There's also what is being called the modernisation of directors and officers' duties. And I think whilst modernisation is a good word to use, it's more of a clarification of the roles of the director. It's not seeking to reinvent the wheel or impose overly harsh duties or change the duties that already exist, but really clarify them again so that people know where they stand when they're serving on the board of a co-op as compared to sitting on the board of a company. And finally, possibly the most important, is the introduction of cooperative capital units. That's a mechanism for raising revenue for the cooperative outside of your membership without diluting member control or ownership. So retaining that member-owned, member-controlled, principled organisation. So we'll just work through these each briefly. Okay, so the terminology changes, the simplest one to understand. So currently co-ops in Queensland are either trading co-ops or non-trading co-ops. So trading co-ops must have share capital. Non-trading co-ops may or may not have share capital, but they must have provisions in their rules that say you cannot distribute its surplus or profits to members other than, the nominal value of the shares might be on a winding up. But the use of the word non-trading and trading, they're really misnomers because all cooperatives engage in some sort of business or trade. Otherwise, why would these organisations exist? So I think the point of the non-trading cooperative had historically been to reflect that, well, they're more charitable, they're purpose-driven organisations, they're not for the profit of their members, so that's why it's not really trading. We're not sharing that profit around. That can confuse people, frankly. So under the CNL, we're trying to simplify it, make it a little bit more accurate. So trading co-ops are now going to be distributing co-ops, and non-trading co-ops will be non-distributing co-ops. So I think these names better reflect the fact that everyone trades, everyone might make a profit, and in fact you want to make a profit just so your business can survive. If you're not making profit, you've got bigger issues at hand. The difference between these organisations is whether or not there's a distribution of profit to members through the shareholding. Okay, so that's why you're distributing or non-distributing. So the fundamentals around what a trading co-op is and does and whether it has share capital does not change. So the non-distributing still remains. You can or cannot have, you may or may not have share capital, that's fine. You still can't distribute surplus or profits to members in a non-distributing co-op, but you could otherwise meet the definition of charity and seek charitable exemptions and register with the ACNC. It's really just to make it clear to third parties who don't understand the model that, yep, you're either for-profit for your members or you're not-for-profit and will not share that profit with your members. Despite what type of organisation you are, all cooperatives, once the CNL is passed, can issue securities such as cooperative capital units and debentures. So you have access to the remainder of the CNL. So the next change, a mutual recognition is what it's being called generally by Queensland. So it removes the concept of foreign cooperatives. So before the CNL came into play anywhere, cooperatives, if they wanted to trade outside their home jurisdiction where they were first registered, had to apply for registration in the second jurisdiction. So essentially you had to provide all your disclosure documents and pay a fee to the second registry to approve your actual trading in the other jurisdiction. Sometimes that was just an administrative process. Other times the registry would get involved and want to actually say, well, we're not sure that this actually meets the test of cooperatives, or your rules have everything required under our particular piece of legislation. So you may have needed to make changes. You once registered in multiple jurisdictions, so 2, maybe 3 if you're based in Queensland and wanted to trade down in New South Wales or Victoria, or vice versa. You also had to provide updates to the registry as to What changes were going? Change of address, change of directors, lodge all your financial statements, lodge changes of rules, and pay all the fees accordingly. So you've potentially got 2 or 3 reporting regimes set up. The CNL wanted to remove that and just say, look, once you're registered in one jurisdiction, that's it, you can trade freely. There's no need for separate reporting, similar to how a corporation is incorporated under the Commonwealth legislation. You know, single registration, single reporting, you can trade freely within the bounds of Australia. So, I mean, under the current Cooperatives Act, it's actually an offence for foreign cooperatives to carry on a business in Queensland. So if someone's established in New South Wales, unless they are registered with Queensland. So that's a real disincentive for other co-ops to come and invest money building up businesses within Queensland. And carrying on a business includes things like seeking share capital from people, seeking members in Queensland, providing any goods or services in Queensland. And particularly for organisations along the border in New South Wales, that can cause issues with, well, are they truly operating in just New South Wales, or are they operating in both, and have they registered in both? So it's sort of been a disincentive to trade across state barriers. It's almost held people back. So now with the CNL, there's no concept of foreign co-ops. There's no need for multiple registration. You just register once, report once, pay one set of fees, and you're done. There is no concerns about, you know, will your business name potentially be inappropriate in another jurisdiction? Will your rules meet the requirements of someone else's legislation, because the legislation is uniform? So it just streamlines the registration process. So again, it's more of a national outlook. You can expand your business horizons to the extent that there was a competitive disadvantage in having to register in multiple jurisdictions, which I think there is, because you're using time and energy and money that could otherwise go into servicing and helping your members, or, you know, delivering goods and services. You're putting that towards admin costs. It removes that disadvantage, and so it allows for more of an even competition with other organisations nationwide, such as companies. I have no idea if there are questions. I'm just going to go through this process, but Anthony can flag them for me at the end. So then the third major change is small and large cooperatives. So when, as a lawyer, you first are greeted with the CNL or the Co-op, or more specifically the Cooperatives Act, you can find there is some confusion as to, well, what are the reporting requirements required of co-ops? Because a lot of the financial records, financial reporting requirements are declared to be applied Corporations Act matters. And so instead of just reading the one piece of legislation, you actually have to read multiple pieces of legislation. So you're always constantly referring to the Corporations Act as to what the requirements of a co-op are. So despite the intention of the Co-ops Act, it doesn't necessarily provide for everything about how the co-op should be organised. So the CNL is trying to bring in all of that into the one legislation. So under the current Co-ops Act, cooperatives are considered companies under the Corporations Act. And so they have to go through the process of preparing financial reports, having them audited in accordance with the Corporations Act. The problem that is faced, I think, by a number of co-ops is that the Corporations Act allows for the difference between small companies and large companies. And it says, well, smaller companies, you're not held to the same burden, the same standard of auditing all of those reports every year. We understand your turnover is smaller, the likelihood of there being discrepancies in the financial report, you know, don't worry about it. You don't have to pay for a full-blown audit every year. And so they've got different provisions for reporting, but co-ops are just deemed to be companies, and so they're deemed to be large companies requiring that auditing process every year. So what the CNL is doing is introducing a definition of small co-ops and therefore large co-ops, and it's separating out those reporting requirements. And so this aligns with the small and large companies under the Corporations Act. Again, you know, providing an even playing field amongst different business structures. So what's the difference? So a small cooperative is one that has not raised funds from the public issue of securities, or if it has issued securities, it hasn't raised more than $2 million from more than 20 people in more than 12 months. So that's the first test. The second test is you need to meet 2 of the 3 criteria on your screen. So the small co-op must also be either have a consolidated revenue of less than $8 million for the previous financial year, or it has to, the value of its consolidated gross assets is less than $4 million at the end of the financial year, or the cooperative has fewer than 30 employees at the end of the previous financial year. And all other co-ops are large co-ops. So smaller co-ops no longer need to submit, no need to go through the audit process unless they actively want to, and they don't have to report that audit to the registrar. The registrar still has the power to direct a cooperative to prepare those financial reports and to prepare an audit if they believe it's appropriate. So while you don't actively have to do it if you don't want to, there's still a right to direct you to do it. Also, your members under the CNL have a right to request that an audit go ahead. So in the first instance, small cooperatives might be able to save some money, save some admin time, but please note that that doesn't mean you will never ever have to do an audit again. And certainly large co-ops, you'll need to keep doing the same reporting you've always done. This is really more of a benefit for smaller to medium-sized co-ops. Okay, so the fourth major change is the sort of modernisation of director and officer duties. Currently, under the Cooperatives Act, the duties are quite short. It's really just 3. So there's the duty to act honestly in the exercise of your powers and the discharge of your duties. An officer must exercise the degree of care and diligence a reasonable person in a like position would. And an officer or an employee must not improperly use information or their position to gain an advantage for themselves or another, or to cause detriment to the co-op. So with the changes being brought about by the CNL, in practice, the duties are going to be extremely similar between the existing duties and the new duties under the CNL. But they're also going, under the new law, the duties are going to be reflective of the duties imposed on directors of companies, right? So again, there's going to be less argument about, well, is the standard to which a director of a co-op is held less than or greater than a standard of care that a director of a company is held? By opening up and changing it to be the same language as the Corporations Act, you're going to have a lot more case law open up, a lot more history as to, well, what does this duty truly mean? How far does this really go? And so that will give better assistance to directors on how they must act, you know, and a fuller understanding of their duties. So under the CNL, a director must exercise their powers in good faith, in the best interests of the co-op and for a proper purpose. This is slightly different to the requirement to just act honestly. It focuses on the co-op, the interests of the co-op. Is it in the interests of the co-op to do this, regardless of whether you're being honest or not? Honesty, I think, needs to be sort of implied, but whether you're acting in good faith, whether it's for a proper purpose, even if it might not be the nicest business deal that you could negotiate morally right, it might still be in the interest of the co-op to go ahead with that, and you might be doing it in good faith. The focus of the board really here is to take into consideration the cooperative principles where it's relevant, because what's in the best interest of the co-op is to make sure that the co-op's adhering to the legislation, adhering to those co-op principles, and making sure that the members are always front and centre of mind. So the second duty is that a director and officer must exercise their power with a degree of care and diligence a reasonable person would do if they were a director of a co-op in the cooperative circumstances. So that's very similar to the existing exercising care and diligence of a reasonable person in a position, in a like position. right? It's a change of language, but it just gives a little bit more information about it has to be a director of a co-op in the co-op circumstances. Then there's the duty to not improperly use their position or information to gain an advantage for themselves or another, or to cause detriment to the co-op. There's also further obligations to ensure that the co-op does not carry on business with too few members, duties to prevent insolvent trading, duties, and then you've got your common law duties, which have always existed, but to ensure that the cooperative can meet its financial obligations to avoid taking unauthorised benefits, and also a duty, again, to act honestly. With that comes from the case law. You know, you must always act honestly when you're put in this position, but that honesty is not mandated anymore. It's also interesting to note, and I don't know whether anyone has relied upon this provision to date, under the Cooperatives Act, an officer is not liable for contraventions of their duties in some circumstances if the cooperative has resolved by an ordinary resolution to forgive the contravention. This waiver, this forgiveness, does not exist in the CNL. The point of the CNL is for proper governance, proper accountability. No one wants to see a director abusing their powers. And particularly where maybe it's a closely held co-op, there is only 5 members and all 5 sit on the board and one of them's done the wrong thing. Oh, it's okay, mate. We'll just resolve to, protect you. That's not okay. If you've abused your powers, if you've done the wrong thing, you should be held accountable. Whether you're actually sued, whether someone brings a cause of damages against you is a different question entirely. But you can't just be forgiven for any transgressions by the members. So that's important to note. With the CNL, proper governance, accountability, making sure directors are accountable for their decisions is critical for a co-op, for a company, for an association, for any type of organisation. And so with the changes with the CNL, there's now consistency, at least across co-ops and companies, which account for a large portion of Australian businesses, as to how they're supposed to behave. If you're interested in more information around governance of a cooperative generally, the BCCM have a carefully considered document which the BCCM considers to be the core governance considerations for CME boards, cooperative and mutual enterprise boards. The document is what's it called? The BCCM governance principles. I'm sure we can provide a link to it at some point, but it goes through at least 9 central principles for CME governance. I think 8 of which are based on the ASX corporate governance principles, but they've been adapted for CME use specifically with unique characteristics of the CME in mind, i.e. the cooperative principles, looking out for the members because it's a member-owned organisation. So then, excitingly, cooperative capital units. This is a hybrid type of security, also referred to as CCUs. So if I say that, that's what I mean. It allows you to raise external capital, external finance, without compromising your member rights or without compromising democratic control. So under the existing legislation, the really 2 methods which you can raise capital, raise money, is through loans, including debentures, or through the issue of shares. But issuing shares to members, issuing further issues, you're looking at a small group of people, probably a limited pool of funds between them. And at the end of the day, one member can only ever hold 20% of all the share capital. So if someone's got deeper pockets than the other, it does not matter. They can't help out. They can't help grow the business. So what the CCU can do is open up the way in which you can raise money from additional third parties without compromising the member control, the democratic control. Having a CCU, you can issue it to members or non-members. It gives the CCU holder an interest in the capital, but not the share capital of the cooperative. So again, it's a way to expand your business, to seek additional funding, without going back to those same people. They're very flexible instruments. You can do a lot with them, and it really comes down to the terms of issue. Some of the key provisions around CCUs in the CNL, a CCU holder has none of the rights or entitlements of a co-op member. They are entitled to receive notices of meetings, other documents in the same manner as perhaps a co-op debenture holder, but they can only attend their own meetings, meetings of CCU holders. They can vote, but only at meetings of CCU holders and only in respect of the terms which govern the CCUs, to change it, for example. They have no voting rights in respect of the main cooperative, how the cooperative functions. CCUs can be secured or unsecured, completely up to the cooperative. They're transferable, so it allows an investor to invest in the co-op, and then if they need the cash out later, they can transfer that CCU to someone else without putting their hand up and saying, cooperative, please redeem these right now, I need it done. They can just transfer it, provided they followed the procedures. It allows for an easier way of doing business for third-party investors that may be disinterested in checking in on how the co-op's going, just wanting this as a return on investment type thing. CCUs are going to be subject to the CNL, obviously. They'll be subject to the rules, your rules, and they're also subject to the terms of issue. So you can have different types of CCUs on issue at any one time. They might have different terms attached to them. So some might be secured, some might not be secured. Some might be redeemed on a particular date, others might be redeemed on the happening of an event or when profit levels reach a certain amount, right? So you've got flexibility. It's not just a one issue and you're stuck with it. You can do one issue and then a few years later you could do a second issue if that's what you really want to do. The terms of CCUs must be approved by a special resolution of members and also by the registrar, right? The registrar is going to also want to see a disclosure statement attached to the terms of issue, which highlight the main risks involved, the liabilities are, what the benefits are, what rights are attached to them. It's as if you are setting up a co-op and wanting to issue shares right at the beginning. The disclosure statement looks very similar to it because you're covering off on the same things. And it has to be approved by the members because this is a significant financial undertaking. It also has to be approved by the registrar to make sure that your document is otherwise compliant with the CNL. You can't obviously do something that's going to breach the CNL, but the CNL is pretty generic as to what is required. So CCUs can only be redeemed out of either the profits of the co-op, the proceeds of a new issue of shares, or an approved issue of another batch of CCUs. So that's a requirement of the CNL. So you couldn't have terms that say, yep, they'll be redeemed out of, a loan that we intend to take from this person. That's not okay. And so the registrar is going to be looking for, well, how is the redemption occurring? But it could be that you make it flexible. It can be redeemed out of profits on a happening of this event, or just when it hits this amount, or not before this date, and then you can request a redemption, and provided that the profit, it doesn't cause the cooperative to become insolvent, yes, we can redeem particular amounts of CCUs. As I said before, co-op rules, you can give a CCU holder one vote per CCU, but it would be one vote at a CCU holder meeting. You can change the terms of issue by a special resolution of CCU holders, so 75%. But again, that's limited to their terms of issue. It's not affecting the operation of the cooperative. So, CCUs, when I've dealt with them, they're extremely flexible instruments. It allows you to raise funds in a way that you haven't been able to before, while it does protect those underlying principles about democratic control and equality. I think they're the sort of 5 major things that are going to change with the introduction of the CNL. They're not scary. They're not substantially altering your obligations. They're really just trying to modernise the ownership vehicle, create consistency amongst cooperatives and amongst other business platforms. I'm hoping that this therefore creates it to be more efficient and effective and become a more common choice of business. But just so I'm not scaring you too much, what's not changing? So the cooperative principles are not changing. They're still in the CNL. They continue to be binding on the co-op and its members. Co-ops are still required to have 5 or more active members unless you get special permission from the registrar otherwise. Each member can still only have 1 vote. Voting attaches to membership, not shareholding. Co-ops still have to have a primary activity and active membership requirements for the members to support that. The formation process remains the same. You still need to have some rules, disclosure statements if you're going to have share capital, have that approved by the registrar, hold your formation meeting and then incorporate. There's still requirements for dispute resolution mechanism, allowing for natural justice as between the members. So how are you going to take advantage of these changes? Well, some of them will take automatic effect. The changes to terminology, for example, the changes to directors' duties, that just will apply. But for some, you will need to update your rules. So if you're going to be considered to be a small co-op and you want to take advantage of the fact you might not need to go through the audit process anymore, you will need to check your rules to see what it says. If your rules say something like the cooperative must have an audit, then despite the changes to the CNL, you still have to have an audit because a cooperative's rules are considered a contract between the co-op and its members. So that's a contractual requirement. So if you don't want that, if you want to opt out, I'd be suggesting changing your rules to something like the cooperative may undergo an audit if requested by the members, as per the CNL, or if otherwise required, if deemed to be a large co-op. So that allows you to grow over the years without having to revisit and change your rules, so that if you are triggered into the large category, you have to go through the audit, but otherwise you don't have to. But that's something you need to pay attention to in your rules. Similarly, with the issue of CCUs, you have to have a provision in your rules that says, yep, we are a co-op that is allowed to issue CCUs. Separately, you then have to have a special resolution about the terms of issue. That can be done at a later date, though the terms can change from issue to issue, but you at least need some fundamentals about whether or not the co-op is agreeing to issue CCUs in the first place. And while I said the duties of directors will just be imposed, you may want to take the opportunity, if you're looking at your rules, to consider whether there should be any additional qualifications on directors, whether they should be undergoing a new course on directors' duties with the AICD, for example, so that they're more familiar with the requirements now going to be imposed upon them. I think if you're going to implement any changes to your rules, you are better off starting the conversation now, not once the CNL is in place. You know, have the conversation with the members, get them on board, have them considering what their options are in terms of rule changes, getting advice, and then once you're ready, once the CNL is in place, you can affect those changes straight away without having to wait or delay months or up to a year, depending on when your AGM's held. Separately to the CNL coming into place, I always recommend that any organisation reviews their rules at least every 12 to 18 months, just to make sure that you're continuing to operate effectively, that the rules reflect your organisation's needs. Is your primary activity still your primary activity? Have you lost focus? Do you need to change the active membership requirements? Are you not getting active members? Are you finding people being cancelled and pushed off the list? And the other thing, just given we're in this COVID situation, think about how your governance of the co-op is actually going. Do you need something that's a little bit more flexible? One specific example is AGMs. We're facing down a second wave. We're doing things by video conference. I think social distancing is probably going to be around for a very long time. Now is the time to develop a contingency plan for holding meetings, for engaging with your members. How are you going to transact business? I mean, if your rules do not allow for the use of technology, you're going to have to start looking for venues that allow for appropriate social distancing whilst achieving a quorum so that you can actually hold your meeting. There's nothing in the Co-ops Act, there's There's nothing in the CNL that says, yes, tick, you can use technology whenever you want. Your rules have to be the ones to be flexible. The CNL allows for directors' meetings to be held by any technology, but it doesn't specifically say that for general meetings, annual general meetings. So look at your rules, consider whether you need to put in a technology clause. I mean, for those of you that don't have that technology, I understand that Queensland have advised that co-ops can seek an extension of time to hold your AGM this year and pay a fee for that, and that fee will be waived, just to allow you some time to find that and to get that in place. I think that's about it from me. I think I've hopefully spruiked the CNL in such a way that you think I'm writing a love letter to it. I truly think having a uniform set of legislations, you know, really important to strengthen the co-op model and the business case for getting more people to establish co-ops as their ownership vehicle, giving you a competitive, it's not even an advantage, it's, you know, a level playing field when it comes to companies so that you can operate better, more efficiently and, you know, achieve great things. That's it from me.
But I'd like to just conclude by saying that that if anything's been raised here that you'd like to deeper dive in, then we highly recommend that, you know, if it's on an enterprise or business level, that you seek, you know, follow-up advice and information from our colleagues at BAL. I'd like to thank you, Katie, for a great enthusiastic presentation on the law. And certainly through the Business Council of Cooperatives and Mutuals and all of the toolboxes and resources that we have been developing over the years, there is information and support, particularly around questions to do with specifics of dealing with the rule changes, COVID-19 requirements such as the AGM issue that came up before can all be found on our websites, which is the BCCM website itself or getmutual.coop, and we'll provide links to all of these things. Unless there's any parting comments, I'll bid you adieu and thank Katie again and wish you the best for the day.